All right, everyone. Welcome. My name is Brian Ponder, also known as the credit lawyer. I'm known as the credit lawyer because most of my practice deals with credit, debt, and real estate issues. You see all that stuff on the wall back there. That's my license. I'm actually a trial attorney in New York. And I guess I'll meet everyone. I leave everyone unmuted because I want y'all to be able to ask questions. Let's see.
Yeah, most of my, let me see. Maybe I have to mute
You
it.
know what? You wanna I do Zooms all the time. You want me to moderate?
Let me actually, you go tell them what to do?
Yeah, well, when they got the noise, so you don't have to keep stopping. I can just mute them when I see that they're not asking a question.
You can mute them from your side?
Yeah, but you have to make me like a moderator.
What's
I
your
do.
name?
Tulisa. Yeah, I trade. So with my traders, we do conferences all the time.
Let me see.
So we always have a moderator so that the person over the Zoom, don't get distracted.
All right, let me do that. So yeah, so everyone, you're going to be unmuted. So if you find yourself with background noise or if you don't have a question, you can mute yourself and then unmute yourself when you do. That will work out best. Can everyone see me?
Yes.
Yep, I can see.
Yes.
Perfect. All right, let me go back to the top. There we go. All right, very good. All right, so yeah, most of my practice revolves around consumer law, which includes credit, debt, real estate matters. I help people with foreclosures, credit issues. So that's why I'm a credit lawyer. Behind me, you'll see some law licenses and degrees. I'm basically a trial lawyer in New York, and I'm also admitted in federal courts throughout the nation: Florida, New York, Indiana, Wisconsin, Illinois, Texas, to name a few. Yeah, I've been involved in credit since 2004. I've been a lawyer since 2008. So I've been dealing with credit about a little over 15 years. I've done it, as a real estate agent, as a credit repair organization, and as a lawyer. So I sort of have all perspectives covered, and I'm able to bring it all to you. Let me see, where's my book? I also am the author. I don't think I have it here. I'm the author of a book called 4 Steps to Better Credit. If you don't have that book, you might want to grab it. And when you do get it off of Amazon, if you email your receipt to brian@brianponder.com, I will send you the letters in the book in Microsoft Word, along with, I think, over a dozen bonus letters. A lot of letters for COVID-19 relief. It's a great thing to have. I even had someone rudely email me and say, I didn't want to buy your book. I just wanted the bonus letters. But I get that. So that's a little background. Tonight is probably one of my favorite topics. It's how to settle debt collections for $0. $0. I know a lot of y'all like, what in the world? How can you do that? Well, I'm going to show you exactly how to do that. And want to congratulate y'all that made it here, because the benefit you all are going to get is that you're going to be able to ask questions at any time. We're going to clarify any questions you may have right on the spot. And when you get off this call, you're going to be equipped to delete debt collections for $0. Now, I'm going to show you a $0 way. I'm going to show you how much are stamps. I'm going to show you how much are stamps now. I don't even know. I just buy them. Are they 52 cents? I don't know.
Say 55.
Yeah, 55. Yeah.
I don't know. They changed the price so much. Y'all remember when stamps actually had the price on there?
Yeah.
Because they changed the price so much, they just put forever on there. They don't even give you a price. But I'm going to show you how to do it for $0, and then we'll talk about how to do it for 55 cents too. But I'll show you both methods. This is an exciting call. Also want to add,
Brian, before you get started, I'm glad I
ahead.
got your email right. because it says command or something in the WhatsApp. And I was trying to email you the copy for my receipt for the book.
Yeah.
I was
Is that,
copying that email and it says, oh, it do say com. For some reason, I couldn't send you an email.
oh, okay. Yeah. Well, you can always put your email in that WhatsApp,
Oh,
but
you know what?
yeah, you can just
I,
forward.
I got the correct one now, but I was
Okay.
over here where you were promoting the book. And that
Okay.
email you put there, it say command, Brian Ponder, Brian@brianponder.command.
Mm,
That's why I couldn't send you that email. Okay, I'm
no
gonna
problem.
resend it.
You'll get that tonight.
Okay, I'm
So,
gonna resend the email too.
so when I learned about this is how I learned about zero debt collection settlements. So first of all, let me share my screen and let's go over some definitions so that we know what we're talking about. So first of all, when we say how to settle a debt collection, we're talking about something that's being collected by a debt collector. So if you Google, first of all, the FDCPA defines what a debt collector is. So you would have to Google 15 USC 1692. That will pull up the FDCPA. You go to 1692 section A, subsection 6, it will define what a debt collector is. The term debt collector means any person who uses an instrumentality of interstate commerce or the mails in any business, the principal purpose of which is the collection of any debts, or who regularly collects or attempts to collect, directly or indirectly, debts owed or asserted to be owed or due another. Isn't that a long sentence? Let me break it down for you. Basically, let's consider it, you have two groups of people. You have an original creditor and you have a debt collector. The original creditor is who gave you the credit, who extended you the credit, who gave you the money. The debt collector is everyone else. So let me give you an example. Say if you get a Capital One credit card, all right, and they give you a $10,000 limit. Your original and your original creditor is Capital One. They're not a debt collector. Say if that card goes bad, delinquent, say if they even close your account and Capital One calls you trying to collect that debt, they are still the original creditor. They are not a debt collector. Even though that account is now in their collection department, Capital One is not a debt collector. So the techniques I'm about to teach you tonight does not apply to Capital One. Now, Capital One, after they've sent you notices, say, hey, pay your bill, please. Let me turn this down. Let me turn that off. Pay your bill, please. And you won't pay it. Eventually closing the account, and they still reaching out to you, please pay us before we have to send us to collections. They're still an original creditor. They're not a debt collector. So Capital One, for example, this is just an example. It could be any creditor. It could be a mortgage. It can be anyone. Capital One, they give up. They charge it off. You look at your credit, it says charge off. Okay? But guess what? They're still calling. That's fine. They're still an original creditor. Capital One says, you know what? We don't believe that John Doe is going to ever pay this bill. We're going to sell this debt, this obligation, to a debt buyer. So they sell that to Midland Funding. Midland Funding is a debt buyer. They buy the debt, then they write a letter to you from Midland Credit Management, their subsidiary, saying, hey, we bought this debt, pay us. Well, guess what? Midland now is the debt collector. All right? Even though they bought that debt because it was defaulted when they bought it. They're the debt collector. So an easy way to understand it is the debt collector is the person you didn't do business with. You know a debt collector because you never did business with them. That's not the person who gave you money, who extended you credit or anything. So all of these methods tonight apply to debt collectors. You have a couple types of debt collectors. One, we just mentioned a debt buyer. A debt buyer debt collector is a debt collector that bought or purchased that debt, whatever it may be, from the original creditor. That's one. Two, you have just a contingency type debt collector that basically on a contingency fee is hired by the original creditor to collect that debt. So you got it? Those are two types of debt collector. You may hear, for those advanced people, you may hear about some debt buyers that claim they're not debt collectors. You may hear about a Santander case or other cases in mortgages, Aquin case or something like that, to say, well, I heard that a debt buyer is not a debt collector. All right. That can be the case and it cannot be the case. Let me tell you when a debt buyer won't be considered a debt collector under the law. If a debt buyer, I'm gonna have to mute someone. If you're talking,
so one for each, every one, every 8 one.
All right. Yeah, we're gonna have to take you up on an
Wow.
offer to co-moderate shortly. Let's see.
Want another one?
All right. Hold on for a second, y'all.
I was saying that you might want to pay attention to this.
All right. So everyone that's on, if you're talking in background noise, mute yourself.
Hey, Derek and Vance and Derek, please mute yourself, please.
Thank you. Thank you very much. So, two types of debt collectors, right? Debt buyer, contingency debt collector. For those advanced people, those super smart people that heard about some certain legal cases, and you all are super smart, but we got some people who say, well, I heard. Well, yeah, some debt buyers actually may not be considered debt collectors under the law. And here are the circumstances. You're gonna be ahead of a lot of people knowing this. If a debt buyer buys a debt from the original creditor before that account is in default, under the FDCPA, they could be shooed in as an exemption or an exception to being a debt collector. You got it? Let me give you an example. Let's just do the Santander case. What if let me give you, actually, let's do a mortgage case. Bank of America gives you a loan. You make your monthly payments every month on time. Wells Fargo Bank buys that loan. Well, we all know Bank of America was the original creditor. Now, Wells Fargo is collecting. You may want to say, oh, you're a debt collector. Well, no, not so fast. That loan was not in default when Wells Fargo got it. So under the law, Wells Fargo may get treatment as an original creditor and not a debt collector. Does everyone have that? Understand that?
I understand that, but I still didn't do business with them. So isn't it something else that can come into play?
Not the FDCPA, but yeah, it's always something. It's something else. Yeah, sure. But
Okay.
But they're not a debt collector. And the reason I'm really honing this in is because this law we're looking at right here only applies to debt collectors. So if they don't qualify as a debt collector, what we're talking about tonight is not going to apply. So I just really have to have y'all understand that. But yes, to answer your question, yeah, it's other things that you could attack with, but not with this tool. Another Zoom night, we'll talk about other attacks. But tonight, we're talking about attacking using the FDCPA. And we only can do that if we're dealing with a debt collector.
Hi, Brian. Hi, Brian.
Yes.
This is Linda. I just want to
Hey, Linda.
I just want to clarify so I make sure that I understand. So
Listen.
they're now considered the original creditor?
Well, let's just say they're not a debt collector.
Okay. Do they have a term, or do we have a term for them, or no? We're just saying they're not.
They may take it the shoes of the creditor. They may stand in the shoes of them. So, yeah, but keep in mind, see, let's go back up to 4. Here's the term creditor. Creditor is any person who offers or extends to credit, creating a debt. So if you bought it that debt buyer did not extend or offer it, right? So, but they're not a debt collector. So it's like an in-between, right? They're not the creditor. They have the legal rights of that, right? You know, it's like an adopted parent. I mean, it's like, okay, legally, okay, they have all the rights of the creditor, but they're not the original creditor. So we can call them, you know, they may stand in the shoes of the creditor, but you know, they are not the original creditor, technically. But the most important part of this is to understand that they are not a debt collector, so that you're not thinking you can go to court on this and win. Let's do that same example with Bank of America. You bought Bank of America, you bought a house, Bank of America extended the loan, gave you the money to buy it. You made 3 payments, you missed the 4th payment, you missed the 5th payment, you missed the 6th payment, you're in default. They write you a letter, Bank of America says you're in default. Wells Fargo comes along, buys this loan while it's in default. Wells Fargo is a debt collector. All right. All right. So those are just some distinctions there because, you know, just so you understand, that's some really advanced stuff there, but just didn't want to leave you thinking everybody that didn't give you the money is a debt collector. There are circumstances that are exceptions, and I just wanted you to understand that one. That's the main one. If you look down here, A, B, C, D, E, F, these are also some exceptions, but you can read that on your own time. But the exceptions that I mentioned just now are really the ones you will probably encounter, and are the ones that the case law pretty much deals with. If you ever say, well, this debt buyer is not a debt collector, or a debt buyer would try to make you convince you that they're not a debt collector because they bought the debt. No, if that debt was defaulted before they bought it, they are a debt collector. Even though they now own the debt, doesn't mean they're not a debt collector. They can be both. All right. Any questions about that? The definition of a debt collector? Also keep in mind, for the FDCPA to apply, it needs to be dealing with the consumer as the person obligated to pay that debt. If this is a business debt, if the debtor is a business and not a consumer, then it doesn't apply. All right. And a debt also has to be a personal type debt, primarily personal. Doesn't have to be completely personal. And the definition is here. It needs to be primarily for personal, family, or household purposes. So a debt to buy a copy machine for your office, well, that's primarily a business debt. That won't apply here. So this applies to personal debt. So I want to spend some time on definitions because it becomes very important to see what applies when dealing with this. All right. Now, I'll tell you a story. In my practice, well, when I first came along, I was about to buy a house. I had all kind of collections, and the mortgage person sort of taught me how to dispute things, pay things off. Back then, 15 years ago, pay for deletion was very, very, very popular. So some of these items I agreed to pay to delete, but that quickly fizzled away for several reasons. Even back then, one, in my practice, I started doing demands for people and telling these debt collectors, look, my client does not agree with this, but they'll pay you a little bit if you agree to delete it. I began to notice a lot of these debt collectors were not willing to do pay for deletion. And then I started saying the same thing, except I said, my client's not gonna give you anything. When I started saying my clients will give you nothing, they started deleting stuff very quickly. They agreed to 0 versus payment to delete. Why is that? Well, these debt collectors have subscription agreements with the consumer reporting agencies. Basically, they swear and promise that they're not going to be doing this self-dealing, compromising the integrity of the credit reporting systems by doing inside deals with consumers. You got it? So they would rather accept $0 and delete a debt than accept 50%, 25, whatever percent you're offering them to pay towards that debt for deletion, because it's an inside deal, and that will compromise their relationship with these consumer reporting agencies. So why would they not want to compromise their relationship with the consumer reporting agencies? Well, credit reporting is probably the most effective debt collection method, because people that are trying to do transactions, the debt collection really harms their credit score. It affects their ability to get financing. And so before you close a home or anything, you're going to have to get these collections paid or off. And so that's how I discovered you really are better off settling debt collections for nothing. Now, how do you do that? You can't just say, I'm not going to pay you anything, delete this debt, right? No, you're not going to do that. You're going to have to present a case to them that challenges what they're trying to collect. Now, to do that, you need to understand it for FDCPA, but I'm going to narrow it down to just two main sections that you need to be concerned about. Let me first go to 1692G. G talks about validation of debts. It talks about the whole dispute process with respect to debt collectors. If you have my book, you want to look at the letter called 1692GB letter. Why do I call it that? Because it plays off 15 USC 1692 GB. Here's GB right here. Disputed debts. It talks about disputed debts. I'm going to read this and I'm going to tell you something. Let's look at that. It says, if the consumer notifies the debt collector in writing. Now, when you're reading these laws, it's okay to go ahead and read it fast, but you're going to have to look there are key words of art in here. So if the consumer, all right, consumer, all right, it doesn't say if someone else. Now, a lawyer can represent a consumer, but if the consumer, that means it has to come from the consumer, notifies the debt collector. So you have to notify the debt collector, all right, not the original creditor. So you can't write capital one talking about what Midland is doing. In writing. All right, so that means to activate 1692 GB, this can't be a phone call. It needs to be in writing within the 30-day period described in subsection A. Subsection A basically says 30 days since the initial communication. Okay, and the initial communication has to have all 5 of these things. If it doesn't, it's a violation of the law. Read this very carefully. All right, within 30 days. That the debt or any portion thereof. So the debt or any portion. What does it mean by any portion? Well, say if that $10,000 credit card that got charged off, say it was a 0 interest card. You just owe that $10,000. However, that debt collector is trying to collect from you $10,010, $10,020. Well, a portion thereof would be that $10 or $20 they're trying to collect on top of it. So that's what they mean by portion. Is disputed. All right. So disputed means it has to be a dispute. You have to say it's a dispute. Or is an alternative to all I just read. Or that the consumer requests the name and address of the original creditor. All right, so you got 2 choices. You can dispute it or request a name and address the original creditor. Or you can ask for both, right? The debt collector shall. So when you see that word shall, that's the word shall means it's a deadline requirement. There's no option. The debt collector has to do this. They shall cease collection. That means they have to stop. Cease means stop. Collection of the debt or any disputed portion thereof. Remember that disputed portion? Until. So until means when something is satisfied. So once what I'm about to read next is satisfied, then they can continue the collection, right? Until the debt collector obtains verification of the debt. Now, verification is not defined, so that's something we have to talk about. Or a copy of a judgment, if there's a judgment, right? Or the name and address of the original creditor, which is one of the options you can request. And a copy of such verification or judgment or name and address is mailed to the consumer by the debt collector. So that's a whole lot there, but this is the most powerful thing right here that's going to allow you to settle a whole lot of debts. Okay. And that 1692 GB letter plays upon this law because it basically triggers, it has all the trigger words in it. Now, a lot of people ask me, well, what if I'm outside the 30-day period? Can I still send it? Yes, you can. All right. Yes, you can. However, I'm gonna have to whisper this just in case they hear it. However, they don't really, if it's outside the 30-day period, what does that mean? The debt collector is not bound to do any of this. But let's not say that too loud. They are not bound to do all this verification that you see here. They don't have to do it. They could throw your letter in the trash. However, who's to say you got that initial communication? How are they going to prove that their initial communication was within 30 days? So anyway, let's not talk about that too much. But this 1692 GB letter has all the key words to trigger this law. Now, if they don't do this perfectly, then they violate the FDCPA, specifically 15 USC 1692 GB. Keep in mind, the initial communication you got from debt collector. Now, let's look at what communication means. Communication is any conveying of information regarding a debt directly or indirectly to any person through any medium. So that initial communication is typically a letter. All right. It could be a phone call. They could call you and say, hey, I'm with Midland. We bought that debt, credit card debt from Capital One. Can you pay us on the phone right now? That's an initial communication. And you say, no, don't call me. Within 5 days, they have to send you this notice with all this information. Now, a lot of times initial communication is not by phone, because if you say, don't call me, it's sort of tough for them. They can actually send you a letter saying they won't call you anymore and include this notice. But that's how that works. Does anyone have any questions so far about what we're covering?
Nope. So all 5 have to be met.
Yeah, and it has to be pretty much verbatim. So let me give you an example. Number 3, well, first of all, number 1, the amount of the debt, the name of the creditor, a statement that unless, so these words I'm highlighting here need to be exact. A statement that, all that stuff has to be exact. It has to be exact because sometimes they'll put, like for example, this part says, unless the consumer within 30 days after receipt of notice disputes related to debt or any portion thereof, it would be assumed. They can't say you have to dispute it with in writing for them to consider valid. So this part doesn't have to say in writing. The next part does say in writing. A statement that if the consumer notifies the debt collector in writing within 30 days, they'll obtain the verification. So this part does have to say in writing. So you got to look, it needs to have all those words in it. And if they change something, it's very dangerous because it may not comply. A statement that upon the consumer's written request, the debt collector will provide the name and address of the original creditor. Okay. So yeah, it has to have all that in. So within 5 days of initial communication. So if a debt collector calls you, you go ahead and look. Within 5 days, you got to have this notice. If they write you, first of all, most of the time it will have this notice in the first letter, but if it doesn't, if they don't send you this within 5 days, they violated the law. What law? 15 USC 1692 GA. So with the 1692 GB letter that you have, you're going to trigger 1692 GB. What does that mean when I say trigger it? Well, when you trigger this, until the debt collector sends you verification of that debt, they have to stop collecting. Now, say if it's already on your credit report. Well, credit reporting is debt collection, so they technically have to get it off of there. Now, verification of the debt, it's not defined. So guess what? It's open. That means you tell them what verification you need. Now, let's go to another law of this FDCPA. Let's go to 1692 section F. Section F says a debt collector may not use unfair or unconscionable means to collect or attempt to collect any debt. That's the law. All right. Unfair or unconscionable means. What does that mean? Well, it could be anything. But after that statement, the law gives you some examples. Examples does not mean it's limited to these 8 things. Those are just examples. It says without limiting the general application. That means we're not limiting what unfair and unconscionable means, but we're going to give you some guidance. Without limiting the general application of the foregoing, the following conduct is a violation of this section. 1, the collection, all right, collection, trying to collect money for someone else or themselves, their debt buyer, of any amount, any amount. What does any amount mean? What does any mean? Does it mean 1 cent? Is 1 cent any amount?
Any.
Is 1 cent any amount?
Yes.
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 Yes,
Yes, it
is.
is.
Yes.
Yes, any amount. It doesn't say $10 over. Any amount, including any interest, fee. You know how debt collectors like to add their fee on there? Charge or expense incidental to the principal obligation. Unless, so unless, remember, is the way out. Unless such amount, so can that amount be 1 penny, is expressly authorized. Expressly. Express meaning it's not something casual. It's actually expressly authorized, like written by the agreement creating the debt, or, so or is the alternative, right? Or permitted by law. So guess what? The 1692 GB letter plays off of this. It will ask them for the agreement. First of all, it'll say, I don't owe you $10,010. All right. So now that's created an amount that's not owed. And then it's going to say, look, give me, I seek verification of this. Give me a copy of that copy of the contract creating that debt that says I owe that amount. All right. So that's, you're setting up that verification to play on this 1692 F1, basically saying, look, I don't owe that amount, and you need to show me how I expressly agreed to it by way of a contract. So you've pinned them down under 1692 GB and have them thinking about 1692 F at this point. So you got several parts of the law they're already hanging up on.
All right, I got a question.
Go ahead.
Now, that agreement that they're sending, that agreement needs to be the original, not a copy, right?
Nah, I didn't say that, but nah, I didn't
Well,
say that.
anybody can copy anything, and signatures, all that stuff is copyable. I mean, like the world we're living in.
Well, think about it. No one's going to send you the original because no, my letter does not ask for the original. A
Okay,
copy of the, I mean, but think about it. I mean, you don't need to ask for the original.
Okay.
If you're in court, you can ask to inspect the original, but just think about it. No one's going to send you the original. Because what can you do with the original? I mean, you can tear it up. You know? But no, your point is well taken, because if it does get to court, you can challenge that copy as not being an authentic one, and you will have to figure out the original. But no, for the purposes of settling this debt for $0, no, you just want a copy of the agreement. If first of all, you're not gonna get it. Okay. Second of all, if you do get one, it's not gonna be a real agreement.
And the bill, because I remember before they sent the bill, and they were saying that the bill, then they were saying that I paid it from my bank account, and I'm like,
is that an agreement though?
No, but they was trying to say that.
All right. Well, we see your bank account here where you paid it. Is that an agreement?
Nope.
It's not an agreement. So first of all, you're not gonna get it, so don't even worry about that.
Okay.
If you do get it, it's not gonna be an agreement, because if I send you a card holder member agreement, just because I call it an agreement, is that an agreement? If I send you a card holder member agreement, who signs it? Agreements have to be signed, executed. Okay. If you join you know, my penthouse club and I, you know, give you a membership agreement after you join, that's not an agreement. That's just some paperwork. That's my policy. That's not an agreement. I didn't agree to that. So anyway, you're not going to get the agreement, all right? And if you do get an agreement, I'm willing to bet you a few dollars it's not even an agreement. It's a pretend agreement. It's not going to have your signature. It's not going to have their signature. So you're not going to get it, people, okay? That's what I want to tell you. So you telling them, basically, you're illegally trying to collect that debt. So this letter, the 1692 GB letter, most of you already have it. You'll notice it gives them two options. You can give me all the stuff I'm asking for. And by the way, what you're doing is illegal. Or you can stop collecting this thing, delete it from my credit report, and we can go our separate ways. All right? Got it? Now, that's strong. That's strong. What you're going to do on top of that is you're going to copy the Cfpb. Does anyone know what the Cfpb stands for? That's the Consumer Financial Protection Bureau. You're going to copy the Cfpb and you're going to piggyback and let the Cfpb piggyback your effort by following up with this debt collector during this dispute process, forcing their hand to comply with what you're trying to get them to comply with. The Cfpb is not going to take your case and do anything for you other than communicate this dispute to the debt collector just like you did and ask them for a response. Okay? The Cfpb collects these disputes and complaints, and when they add up and they're not resolved favorably, the unfavorably resolved ones, after they get so many unfavorably resolved complaints, the Cfpb will like, you know what, let's go after these people. So that's your secret weapon, where you'll be able to fax this letter to the Cfpb. Now, how much money have we spent so far doing this? How much money have we spent so far disputing this?
None.
How much money have we spent so far?
$0.
$0. So we're gonna e-fax this letter to the Cfpb, and if we want to spend $0, well, how are we going to get this letter to that debt collector for free? We can fax it, look up their fax number, Google. You can look up the company, go to their website, look for their email address. You could have someone call and ask for their fax number or email. That's how you can do it for $0. Now, you know, if you're rich-blooded, you can just print the thing out and mail it, you know, for you rich folk that want to settle it for 55 cents. Send this letter off and let it do what it does. Now, if you want to get real fancy, you might want to send it certified mail. Don't necessarily recommend this particular. I don't recommend it, but you can. So
I have a question.
go right ahead.
Are we dealing with the collector directly, or is this something that's been verified by the credit bureau first?
All right. Who was that talking?
This is Cedric.
All right. Cedric, you were here the whole time?
Just about, not the first 30 minutes.
Okay, because we're dealing with the debt collector. I have not talked about, we're dealing with the debt collector. Everything I just described, this letter is going to the debt collector. And actually the 1692 GB letter does say via certified mail return receipt requested, because I want to give you the most certain way this thing is going to get there. But if you want to do a $0 type situation, you can always fax or email it, e-fax it. But this is to the debt collector.
Okay, got it.
We're not
All
doing
right.
anything with the original creditor. We talked about that in the beginning. We're not doing anything with the original creditor. We have not even mentioned Equifax. We have not even mentioned a CRA. Why not?
Okay.
That's a good question, Cedric. Why not? Why are we not sending anything? Well, guess what? The way we're doing this, we're going to have that debt collector do all that for us. That debt collector is going to stop collecting that debt, and that debt collector is going to erase their credit reporting. We don't even have to dispute with the consumer reporting agency. We're not even going to submit a dispute there. Only if they disobey us and they don't do the right thing will we ever have to go to plan B or step 2. But no, we're not even going to do that. The debt collector is going to do all that for us, because we have this 1692G bid letter that triggers all the bells. It rings all the bells that we need to, and we give them 2 options. You can prove to me that you're not breaking the law, or you can cease and desist collection and delete this debt. Now, have we offered them any money to pay for delete?
Nope.
No, we didn't, and we're not going to. You don't do that. That's like negotiating. Why would you pay me? Why are you offering to pay me if you don't owe me? I don't trust you now. I mean, why would you offer to pay me? So we have some type questions here. Thanks, Trading Spot. D. Charles says, so when you activate a pre-approved card by mail, that's not really an agreement because it was done over the phone with no signatures? Yeah, so good question, D. Charles. So yeah, activating a card by mail, is just that, activating a card by mail. That's not an agreement to pay $10,000, right? It's not an agreement. But no, card activation is not an agreement. Now, the credit card, if you sue the credit card company, they may, say otherwise, but again, we're not dealing with the credit card company, we're dealing with the debt collector. But yeah, even over the phone, you're not going through agreeing to something specifically. And again, you have something that's called statute of frauds. Even if it was an agreement, oral, it has to be in writing over a certain amount. So in your state, you can type in Georgia statute of frauds, New York statute of frauds. Some places, anything over $1,000 has to be in writing by agreement. So you got different statute of frauds provisions, basically saying even if it is like an agreement, if it's not in writing, if it's not an agreement in writing, it doesn't count. Vance asks, who are credit bureaus? I'm lost. Yeah, we haven't talked about. You have consumer reporting agencies. So all of this is directly to the debt collector. Any questions thus far, y'all?
Hi, Brian. This is Linda again.
Hey.
I have a question. In the beginning, you were talking about 2 types of debt collectors, the debt buyer and the contingency debt buyer.
Mm-hmm.
That being said, if the debt collector is the contingency debt buyer, don't they kind of still have access to the original creditor, and could they still be verified?
Yeah, but you're not gonna. Yeah, yes. And someone has TV background. If you mute, yeah, they do. So they should be able to see that agreement, right?
That's what I'm thinking.
Think about it. The debt buyer, that's like you buying a car. You got the manual with it and everything. You should have access to it. The contingency debt collector, they work for the person. They should be able to go back to them and say, hey, he's asking for the contract. Can you send that over so I can go ahead and collect this debt for you? You're not going to get it.
They supposed to already have it anyway, right?
Yeah, they don't. They don't. Nobody has it. Nobody has it.
Right.
Nobody
Okay.
has it. So anyway, this is look, people have eliminated so much debt like this. Now, let me ask you a question. No one has asked this question. Well, what about Capital One? Capital One is still on my credit. How's your credit report look? That Capital One is still in the credit report, right?
Yep, charged off.
All right, it's charged off. And then Midland bought it, and now Midland has it on the credit report too. So Midland, they chose the debt collector, whoever it may be. They said, you know what? I don't want any problems with this person. I don't want to. They sound like they're dealing with a lawyer. It sounds like a lawyer helped them with this. They're going to write a letter back saying, we're not going to collect this anymore. We're deleting it off your credit report. So what happens to the credit report? What comes off the credit report?
Just
The collection account.
The collection goes away. What about Capital One? Does that come off?
Still there.
Nope.
No, it's still there.
It's still there. So that's another Zoom, huh? That's a whole nother call, right? So, but we took that collection off. Why can't that debt collector take off the original item?
It never
They
was
can't
there.
control what the original creditor does.
That's correct. That's correct. So that's another Zoom on how to get that original one off. Okay.
What'd he say?
What was the comment? Why didn't the debt collector deletion take care of the original credit? Someone mentioned
It's two separate entities, so you gotta challenge each one separately.
right. So that's a separate entity. So that's a whole nother Zoom on how to get that original credit card off of there. We can do it. We can do it. We'll do another Zoom on that, maybe a day or two. But that collection is going to go away. Is that going to help your credit though?
Yes.
It's going to make a huge difference.
That's going to help your credit because that's one less negative item on your credit report.
Yeah, it's going to help the credit. Now, that charged off credit card, what's the balance going to be on there? That balance could be zero. So it's going to help you. But guess what? If you want to be a real credit master, we want to do something more and get that off of there too. So, but what we talked about tonight is going to take that collection off, which is nasty. Collections are nasty. But that original debt is still there, and we do want to get that off. We'll do that. We'll talk about how to make sure that comes off later. But we've spent $0. So now the CFPB is actually, this 1692 GB letter, we're going to be sure to put your name, address, email, and everything on it, because guess what? The CFPB, when they get this letter, I don't know how they do it. I mean, within a day or two, they're going to email you saying, we got your letter. We're going to contact this. They may say creditor, but they talk about the debt collector. Within 15 days, I mean, this debt collector is going to respond to CFPB, going to respond to you. Now, guess what? When they respond to you, they're going to respond to you saying, oh, we you know what? We're going to stop collecting it and we're going to delete it. They're going to go to CFPB and say what? Yeah, we don't collect. We're not collecting this. So that's why it works, because you're getting what you want, but technically they're sort of keeping a clean record with the CFPB, because when the CFPB comes after them, after they accumulate so many unresolved bad issues, it's not pretty. I mean, we're talking millions. So now let me ask you a question. Does that mean every debt collector is going to delete and cease and desist?
No.
No. You know, are more than less? Are they more so than not going to delete it and cease? In my experience, yes. That's why I'm able to sell this letter. I sell it separately. I sell it in my book because it works.
Brian, this is Misha. I have a question.
Okay.
So could I use this letter for multiple debt collectors? Like I have a client that has 4 on her credit report right now. And she was talking about looking at paying for deletion. But I'd rather not, now that I know what I know, I'd rather be able to send each of those debt collectors that 1692 GB letter and then open up a case with the Financial Bureau.
Yes.
Now, could I have multiple accounts open with the FCB?
CFPB, yes. Okay. Unlimited. They don't care. I mean, I don't see how they keep up with all this. But yeah, absolutely. When y'all hang up from this phone call at night, no more pay for deletions. The only time I recommend you entertain a pay for deletion is when? Can someone guess?
If
When
they
it's a
try to
lower
sue
amount,
When it's
if
the
they try to
original
sue you,
credit?
With a debt collector. The answers I've heard so far, no. So the
They have to
question
have all
is,
their paperwork in order. And have a
that's a good one. That's not what I have in mind. Anyone else want to give a stab at it?
If you want it quickly for like a home closing or something?
When you
No,
need it.
it's not about quickness. This can happen. This can happen quickly. I'll tell you when they offer it to you.
Oh.
Okay.
Let them offer it to you. Don't you ask for it. So yeah, if they offer it to you, hey, you can consider it. But don't you ask them for it. You tell them I ain't giving you nothing. Y'all are violating me. It's illegal. You see it in my letter. Do not. But those are some good answers, you all. But no, this happens quickly. And the original creditor, yeah, I mean, even the original. Well, that's another Zoom. The original creditor.
Now let me ask you, why are you saying to pay them then if you're saying not to pay them? And if they do pay for delete, you're saying to pay them.
No, my statement was the only time you should ever entertain a pay for deletion is if they offer it. If they offer it, hey, and if it's a good deal, it's a business decision at that point, right? So it's not about not paying them. Remember, okay, first of all, what's the goal here?
To get it off the report.
We want that report cleared.
Of course.
So we're not, if they want to offer it, look, hey, if you give us $100, we'll delete that $10,000. Give them $100. First of all,
I would too. In case over, you move on to the next thing.
Absolutely.
Listen,
So I'm just saying,
time is money, brother.
That's right. But don't lead with that.
No,
because it's a sign of weakness. And two, if they want to self deal with you against their subscriber agreement, let them do it. It's like, okay, right? So, okay, we're contacting Cfpb. They have a question via fax or their website. Fax. I have a fax number. Fax number is 855-237-2392. So I recommend fax. You can register. You can go to the Cfpb website, register, and maybe upload it there. That'll work too. But you can also just fax it. So either way, Ms. Baker asked that question. Repeat fax number. The fax number Cfpb is 855-237-2392. I'll put it right here. Cfpb fax. So do y'all have it? We went over this. This is probably the most information. I mean, we did it within an hour, but this is powerful, y'all. You can delete. Now, does it matter how? Let me ask you a question. Does it matter how big the debt is? What if it's a $60,000 debt?
Nope.
Does not matter. This could be a mortgage. It does not matter. This can be $100,000 debt. Okay, this is very powerful, people. Very powerful. Don't be afraid. I want to talk just 60 seconds about mindset. First of all, go back and review what we did, but understand or have a mindset that, first of all, like I forgot to say, the goal is to delete this thing, and so don't stop until it's gone. So understand it can be deleted. We have a couple of questions. Do you include the social security number, date of birth, and sign a letter to the debt collectors? I always thought you didn't give them that information. Actually, my 1692 GB letter does give the social security number, and it does give the date of birth. Now, you can redact some of that if you want, just give them the last four. But I put it all out there because I'm telling you, what you're doing is illegal. Now, if you want to take my social security number and do, first of all, it's already on the credit report. They already have it. So it's like, but yeah, I include it because you don't want them to come back and be like, who are you again? You're John Doe. We have a lot of John Does, but yeah, I put it in the letter. And you're so confident. You're like, look, here's my, yeah, look, here I am. Here's my social security date of birth. What y'all doing is illegal. So it's like, you're not afraid to show them who you are because what you're doing is illegal. Look me up. Here's my number, date of birth. Here we go. Your 1692 GB work for me. Okay, this is good. Richard M says your 1692 GB worked for me 3 times, but only one didn't remove it. LVNV. Very good. Congratulations, Richard. LVNV, I would recommend, Richard, send that to Resurgent Capital Services, LVNV now. Send it to them, and first of all, implement the CFPB. They're going to send you some BS. Just respond. This is not an agreement. If you better reconsider this letter and stop sending me this garbage. This is not an agreement. So yeah, you got a couple of them that will send you some garbage that's not an agreement. All right. Cedric Carter, Zoom is awesome. All right, yeah. So y'all should be very confident like Cedric, and proceed accordingly. $0. But if you want to get fancy, you can put a stamp on it. You can mail it, or if you want to get super fancy, you can send it certified mail. Now, with this COVID-19, do not be going to the post office. You can go to letterstream.com. You can send a certified letter that way. I also use certifiedmaillabels.com. Do not be going to the post office in this day and age. All this stuff can be done right from your laptop. All right. E-sign the letter. If you have a scanner, sign it, scan it. If you don't have a scanner, I use Sign Easy. You know, you can use different apps to sign your letter.
Can you put that in the Zoom? I'm trying to remember to use websites and stuff.
I was about to ask, are we going to watch this recording?
And then certified.
Okay, thanks, Brian.
.com. So y'all, you know, and look, we about to wrap this up. So listen, I'm putting together. If you attend 5 of these Zooms, I'm gonna put together some quizzes. All right. So this Zoom will have a quiz, and I'll send it to y'all later. But if you go through 5 Zooms and take 5 quizzes and get 70%, you'll pass it. You're going to be what's called a credit master. Nobody be able to touch y'all. Nobody, I mean, come on. Nobody be able to touch y'all. So we'll get you a certificate, sort of like the ones behind me, a credit master certificate. So I'm putting that together. So you'll have access to the old Zooms to review and study, but you're going to take, it's going to be 5 quizzes, at least 5 passing quizzes. You're going to be what's called a credit master. You know, who can touch you after that? I mean, this one Zoom right here, you can delete, 6 figures of debt off of this one Zoom. By the time, if I give you 5 lessons, you're gonna be a credit master. Nobody will be able to touch you. All right. Any other questions? We're about to wrap this up.
Yes. Could you type those websites you mentioned in the chat?
Yeah, I did.
Okay.
I did. Oh,
no.
Oh, I'm sorry. You know what? I'm sorry. You know what? I sure didn't. I typed it to one person. Oh, I'm sorry. Here we go. Letterstream.com, certifiedmaillabels.com. That's how you can send those things certified mail or regular mail. You can actually send a regular mail item just like that too. But yeah, you want to be official? Yeah, you can send it there. But this is how you do it, you all. Do not offer a pay for delete. Don't do it. If you don't have my book, get the book, get my letter. Don't try to wing this. Don't reinvent the wheel. The book is only $25 and you're going to get over a dozen letters, including the 1692 GB letter. Don't.
Brian, may I add, I bought 2 of your birthday packages and you put a lot of stuff in them packages. I appreciate that.
You're very welcome. Who's this?
To Lisa. My Facebook name is Lisa.
And you the trading spot? Let me see.
Uh-huh.
Oh, okay. Well, thank you.
Lisa Spencer. I done bought I think all the packages you put up so far. For $42, that was a lot of information. Yeah.
It's good. Yeah, look, y'all. My whole thing is this information is value. I mean, you can't really pay the value of it because my student loan deletion package, I mean, I've deleted, multiple six figures off of that little package, and it's just $100. So, Brian, what did you say about the e-sign? Was it a website? Oh, okay. Yeah, Sign Easy is what I use. SignEasy.com is a site that you can sign. So anyway, yeah. So my whole thing, you all, I was trying to say is, I'm not trying to price stuff where you can't get it, but so yeah, the value, I'm not pricing it by value. I'm just pricing it nominally.
Hey, baby.
So that I can earn a living and so that you can access this stuff. Okay.
Huh?
And you use that, you'll be good.
I
Any
still
other
have
questions
to
you want?
do a little bit of data entry and write the checks and stuff.
Hey, Cal, we hear your whole
Do you
conversation.
want to come up and help me?
All right. Let's
Huh?
see. Let's go. Oh boy. Any other?
Well, I mean, if you want to, you can. You don't have to.
All right. So we're gonna get a co-host for the next one, and we're gonna get this cleaned up.
Bingo.
All right. So everyone, great session. Great.
All right. Well, then let me finish up, and then I'll be there.
Great questions, and we're gonna have a co-host for the next one to help me. And everybody have a great night. Okay, be safe.
All right, you too. Thanks a lot, Brian.
Oh, I think I only have like 6 checks.
Very welcome.
Thank you, sir.
Just check back with me at 9:30. That's 25 minutes.
Thank you, Brian.
Okay, love you. Bye.
Very welcome. Very welcome.
Thanks, Brian. Bye.
You're welcome.